Hi, I'm Dave Clapp, your 2020 president. Welcome to today's session on unconventional ways of getting to yes in an uncertain market. I have the pleasure of introducing our speaker, Gary Kaufman. Gary is a real estate attorney with the firm of Ban Law Group, PA, in Sarasota, Florida. His practice encompasses both residential and commercial real estate, including title insurance, closings, purchase agreements, loans and mortgages, commercial leases, easement agreements, and condominium developments. He represents sellers, buyers, landlords, tenants, banks, and investors. Gary handles closings, including title work for real estate purchases and mortgage refinancing. He has also represented developers, including large multifamily and office projects located throughout the county. Some of his prominent projects in the area include Courthouse Center, Sable Palm Plaza, Bank of Tampa Building, Beach House Residences, Regatta Village, Civics ESA Plaza, Rosemary Square, and 1500 State Street. Please give a warm welcome to Mr. Gary Kaufman.
To the seminar, just give me 1 second because I'm apparently doing my own technical thing. So on this thing, I click this. How do I make the change?
Share screen. Did you click share screen?
Oh, share screen.
Yeah.
Ah, it's always something.
It's hiding there. There's the green one. Okay.
All right, then just click share.
No, click on the slide presentation.
Here. Slide 1.
Yes.
Then share.
Yes. Okay. Do from slideshow from beginning.
All right. Well, I thank you for your indulgence. This is my first time using this technology in this manner. I want to thank the Realtors Association of Sarasota and Manatee County for having me here as your speaker today. I am Gary Kaufman. I'm a real estate attorney with Ban Law Group. As the presenter mentioned, I do both residential and commercial projects, and it's actually in a lot of the commercial projects where I've learned a lot of creative techniques that I've learned to adapt to residential closings. I'm also a title agent. I'm licensed with Old Republic National Title Insurance Company, and this is typically where I would first meet realtors like yourselves and your clients. This seminar will explore the creative structures and how to overcome hurdles, how to close the deal, how to get to yes, and frankly, get your commission when a home doesn't appraise, when a buyer perhaps needs 9 to 12 months more before they can qualify for financing. If the house maybe needs significant repairs, but the seller isn't willing to adjust their purchase price. Obviously, what you all want is a willing buyer, willing seller, willing to pay full cash, and a quick, easy closing. That's your plan A. What I'm giving you is opportunities to have a plan B and a plan C if you need it. So we're going to explore creative ways of getting to yes, including structures like seller financing, the lease option, lease purchase, contracts for deed. We'll touch on that in wraparound mortgages, rights of first refusal, and a little bit of land trusts. So without further ado, I go to my next slide. I already should have been to the next slide. There's that. Okay, that's what you should have seen during my introduction. All right, seller financing. I kind of changed the title to creative ways of getting to yes instead of unconventional ways, pretty much because seller financing is a reasonably conventional way of getting a deal done. But I want to talk through some of the aspects of this. Seller financing is very advantageous for a seller who wants to close quickly. There's no loan applications, no appraisals, no underwriting. Number two, sometimes it's a way for a seller to get her price without having to make concessions. A third advantage is a tax advantage. is that seller financing gives a seller an opportunity to defer capital gains taxes. So let me do a little bit of a background on this. On a sale, a sale of a primary residence, you have something called a Section 121 exclusion. And what that means is if your house is going to sell for up to $250,000 more than you paid for it, you will not pay capital gains taxes on the first $250,000. So for sale of a primary residence, the capital gains tax savings is particularly important if the appreciation is greater than this Section 121 exclusion. Deferring capital gains is also good for investment property or for residences that are not primary residences. The IRS treats a seller loan as an installment sale. And as an installment sale, it defers a seller's recognition of the gain, which basically defers the taxation. So that's one of the reasons why some sellers like doing seller financing. Another reason is that you avoid any lender imposed repairs. There are certain types of situations that you may have seen where a lender requires repairs, particularly in FHA types of loans. So there's another reason why this might be an attractive alternative. And another advantage to a seller is sometimes the seller, frankly, is going to make some profit on the sale, and they don't know what they're going to do with their money. They don't know how to reinvest it. And sometimes they just like the idea of reinvesting it right back into a mortgage on the property that they had owned for a number of years. So those are the different incentives to a seller. The primary candidates for seller financing is a seller who has little or no debt. As you can imagine, if a seller has a high mortgage, it's hard to do seller financing if you're going to have to pay off most of it in the form of a debt. Second is a seller who has highly appreciated property to take advantage of the tax benefits of the installment sale. A third primary candidate might be a seller who just is not willing to change their, to reduce their asking price, but they're willing to barter their willingness to lend in exchange for getting their purchase price. And perhaps, again, somebody who wants an opportunity to reinvest their profits. So what are the advantages to a buyer? A lot of these things that I was saying for the seller are also advantages to a buyer. The buyer may want to close quickly. You can get, if you can get the seller to agree to carry financing, obviously it avoids the underwriting and appraisal process and so forth. A buyer who has short-term financing challenges. For example, a buyer who may be going through a divorce or having a short-term downturn in their business, maybe because of COVID, but overall has strong financials. They feel like within a year or two, they'll be able to get their finances back together again. That's a perfect candidate for one of these situations. A buyer, another advantage is that a buyer can enjoy lower closing costs. They don't have to pay for the appraisal. They don't have to pay for points. So a lot of lender costs that you can save. Now you have to contrast with that with the fact that a seller who's taking back financing is probably going to charge a higher interest rate than an institutional lender that does an institutional loan backed by Fannie Mae or Freddie Mac. But it's just another advantage, at least on the closing cost side for the buyer. And a last thing is the flexible down payment. Now this is all negotiable. Buyers and sellers negotiate this. When I'm talking about the first three creative options, seller financing, lease option, lease purchase, what I'm assuming in all three of these situations is that the buyer has the ability to come up with a significant down payment that is enough of an inducement to the seller to do one of these structures. I will talk a little bit later on about a situation where a buyer does not have the ability to put down a big down payment. Another type of consideration that a series of considerations that you have to think about for seller financing is the Dodd-Frank Act. The Dodd-Frank Act, in the aftermath of the Great Recession, Congress passed the Dodd-Frank Wall Street Reform and Consumer Protection Act. This is sometimes an annoying piece of legislation that makes things harder for title agents and certainly for realtors who are trying to close transactions. But in particular, it theoretically should not be applying to seller loans, but it does. Under the act, a lender, even a seller lender, is considered a loan originator under the Dodd-Frank Act. And as a loan originator, the seller as a lender will be subject to the same licensing and regulatory and disclosure requirements. So how do we get around that? There are a bunch of things. I mean, first of all, just be mindful that the punishment for non-compliance of the Dodd-Frank Act can really be severe. There can be cash penalties. There can be legal fees, rescission, refund of costs and profits. A seller who enters into a seller financing transaction and is not compliant with the Dodd-Frank Act is doing so at his or her peril. So I can urge you to consider that. Good news is that there are some solutions. One thing is that the Dodd-Frank Act applies to sales of residential property, primary for personal residences. So if you are selling commercial property, this does not apply. Second thing is it does not apply to what they call a non-consumer buyer. So that means that if the buyer is a corporation or an LLC, it is at least arguable that the Dodd-Frank Act will not apply. Third thing, which is something that we typically rely on here, is what we call the One Property Exclusion. If a seller finances one residential property within 12 months, and that seller is not a contractor or developer where they're doing this on a routine basis, they're not in the business of doing this, they can be subject to an exception to the requirements of Dodd-Frank. There's a challenge sometimes to this one property exclusion because it only applies to individual sellers. So for example, if you own the property as a corporation or an LLC, you're selling it to a buyer who's buying it for the purposes of primary residence, you will not be able to take advantage of this one sale exclusion. Now, there is a second exclusion called the three property exclusion, which is good for an entity seller, but in that case, the loan must fully amortize. You cannot have a balloon payment. So what are balloon payments? Balloon payments is very traditional in seller financing. Institutional lenders who make a loan and can sell their loan to the secondary market have the ability of cashing out on their loan to sell it to the secondary market or to another bank, rather than holding it for 30 years. If you as a seller are doing a loan, even if you use a 25 or 30-year amortization schedule, you typically want the buyer to refinance and take you out within 3 to 5 years. That's called a balloon payment. That is allowed under the one property exclusion, is not allowed under the three property exclusion. So if you have any issues in seller financing, you're welcome to call me or email me, and happy to discuss it with you outside of this seminar. So some legal issues to consider when you're doing seller financing. That is, number one, is ask your title agent to issue a title loan policy to the seller to insure the mortgage. In other words, we are treating the seller as the same way you treat any other lender, which means that they get insurance coverage to ensure the viability of the mortgage that they're going to have on the property. Number two is homeowners insurance. Just as any institutional lender would ask for homeowners insurance to name the lender as an additional insured on the liability policy and a loss payee on the property casualty policy. Well, you want to do the same thing for the seller. Third thing is the documentation. The documentation typically involves a promissory note and a mortgage. There's sometimes ancillary affidavits and things that we will throw in as attorneys. But again, it's the same documentation that an institutional lender does. The only thing different about a seller financing is that you're not going through an underwriting process that an institutional lender will go through. Closing costs. Just as with an institutional loan, there are closing costs like doc stamp taxes on the mortgage, just separate from doc stamp taxes on the deed, intangible taxes on the mortgage, recording fees to record the deed, and attorney's fees to prepare the note and mortgage. These costs are typically buyer costs. It's subject to negotiation. If the seller is really motivated to make the deal and has the ability to pay and the buyer doesn't, then the seller can pay these costs. But the norm is that the buyer would pay all the costs relating to financing. And another cost, of course, would be the cost for the title premium. Although if you do simultaneous issue, you get an owner's policy, the title cost for the loan policy is just $25. An issue that comes up that people don't think about in seller financing, and you should, is the escrowing. You know, an institutional lender will escrow property taxes and insurance. Now, it is not standard for a seller lender to get involved in issuing these, escrowing these taxes. And frankly, it's a burdensome thing for a seller that they're not set up to do. But what I typically do, put in the mortgages, is state that in the event that a borrower is in default, the seller has the right at any time to require escrowing of taxes and mortgage. That's usually the compromise position. But I want you to at least think about that if you go into this. Next thing is the down payment. So we already discussed this. Most sellers who do seller financing are not going to want to give 95% loan to value or 100% loan to value. Now, they may do that if the buyer is their kid, they're helping somebody out. But if it's an unaffiliated third party, you're going to want something down to make it more conservative for the seller. At the same time, it's all subject to negotiation. And if the buyer is unable to do it, then the seller has a choice of whether they do the deal with this buyer or they move on and try and find somebody else. If the buyer is taking title through some entity, make sure to get a personal guarantee from the principals of the entity. The last thing that a seller lender wants, just as any seller, any institutional lender would want, is to have to pursue a judgment against an entity that has no other assets. Obviously, you have the property as collateral, and if the value of the collateral remains strong, you won't need to pursue them on the note or on the mortgage. But if the property value goes down, you want to know that you have individuals that you can pursue against. Ask for a balloon payment. So again, I would recommend that any seller providing seller financing asks to have the buyer refinance within 3 to 5 years. The terms are all negotiable. What I typically see is people offering a 25-year amortization period with a balloon payment in 3 to 5 years, but you can offer a more aggressive amortization period of maybe 10 to 15 years if the buyer can afford it. It's obviously more conservative and better for the seller, worse for the buyer. These are all things that you have to consider and negotiate. One thing that sellers don't think about doing is underwriting their borrower's ability to repay. Lenders obviously go into the finances and they get financial statements and bank statements and tax returns. In most cases, the seller simply relies on the fact that they rely on the story that the buyer tells them. And if the buyer is willing to put down 10 to 20% down as a down payment, and then pay pay a decent interest rate, usually the seller is comfortable. But there are certain circumstances, particularly if you don't get a significant down payment, where you might want to investigate their ability to repay. The last thing I would mention is construction improvements. If you have a buyer who wants to go there and do renovations, just talk this out with your attorney about how to manage that. So you as a lender should have a clause in your mortgage prohibiting this without your consent. And yet there are situations where a borrower is willing to put money in the property as part of the inducement. Maybe instead of giving you a 20% down payment, they're only giving you a 10% or 5% down payment, which by itself is not very good. But if they're willing to put $100,000 to $200,000 down in property improvements that will make your property more valuable if you did have to foreclose, and obviously just psychologically, nobody's spending all that kind of money without the possibility of getting the proper, being able to stay in the property. So you should have the right to approve those, but you want to be flexible and maybe give your buyer that opportunity to make those improvements, as long as you see that they have the ability to pay and that they don't lien your property, or that liens are managed so that they don't create, that failure to pay contractors does not become a seller problem if you foreclose. So those are the things I wanted to talk with you about seller financing. May I have the next slide? Oh, that's me making that happen. There's the next slide. The lease option. All right, so I want to go through some background on the lease option. The lease option, first of all, I want to distinguish a lease option from a lease purchase. I hear people all the time using these terms synonymously, and they're not. As the names indicate, a lease purchase creates an affirmative obligation on the part of the buyer to close on the property at the closing date. A lease option, as the name indicates, does not create any affirmative obligation. The buyer can close or can choose not to at their discretion. So that's the big distinction. A lease purchase is essentially a purchase agreement with a delayed closing date. Now, I mean, I guess in some respects, every purchase agreement has a delayed closing date. You don't typically close on the day that you sign the contract, but usually the closing date is 1, 2, or 3 months after signing. This way it could be a year, 2 years, or 3 years after signing. But just definitionally, I want you to understand what we're talking about. I want to talk about some other alternatives out there that are sometimes used. I don't prefer them. There are reasons why, which I'll get into, but just for educational purposes, there's a concept called a contract for deed.
Gary, this is Jessica. I'm sorry to interrupt you, but we're having some issues seeing your slides on our end. Are you able to go to the screen that you're on?
All right, getting an interruption. What, can you say that again, please?
We're getting some feedback from the attendees that they can't see the slide you are on. Can you go to that slide on your share screen for me?
All right, I'm at that slide.
We're not able to see that on our end here.
All right. You are screen sharing. My technical advisor is here.
Share screen again.
On here.
Yeah.
On here.
No, go back into here.
And here.
Yeah, go to share screen.
Yeah, I'm not seeing it up here.
Click here, Gary, to go back and go into full screen here. Do this little blue box.
Yeah, I tried that already. That's not it. All right. For those of you who do not, we're going to continue trying to look and see what we're doing here. Let's just take one last shot here. Can you see that, Jessica?
We're still seeing the title screen on our end.
The title screen?
Yes. Perfect. I can see you moving through the titles now.
Okay, is this the right screen now?
Lease options?
Yeah.
Yep, perfect.
Okay. Well, as a friend of mine once said, education, that's what you get when you don't get what you want. So obviously, I learned something here technologically, but there was a little bit of a delay. Thank you for your indulgence. All right. Where I left off is I was talking about the contract for deed. I'm using this really mostly as a contrast to the lease option mechanism. A contract for deed is essentially purchasing property on the layaway plan. It means that you purchase the property. It is an insurable transaction. You can get title insurance for it. And yet it's a bit confusing because my title company has said it's an insurable transaction, a contract for deed. And a litigator that I know who specializes in real estate says that contracts for deed are not recognized by the state of Florida. But essentially, it's purchasing property on the layaway plan. The buyer takes possession. The buyer makes a payment each month, and each payment is applied towards the purchase price. But the deed, the actual transfer, doesn't happen until the very end. So the deed comes at the end of a very long and winding road that might take decades to travel. And I'm identifying it as a possibility. I find it to be more complicated. It's one of the things I like about a lease option is just having more traditional remedies that judges and practitioners understand. If a tenant defaults under the lease, your ability to evict them. So that's another thing. There's another issue for lease options and lease purchases in a situation where a seller has a mortgage on the property. Back in the 1970s, interest rates were around 7%, and they started rising very rapidly after that. It went up to 10% and then to 18%. And it was very commonplace for people to sell property and take back a mortgage, keeping the existing mortgage in place. So that means that the seller is making a loan to the buyer, which was technically a second mortgage, and the seller is keeping their first mortgage in place. These were sometimes structured as wraparound mortgages. But part of the reason why this seller financing was easy to do back then is because the mortgages, the traditional Fannie Mae, Freddie Mac mortgages, the standard documentation did not create what we call a due on sale clause. Every mortgage has a due on sale saying that the borrower can pay monthly until the end of the term of the loan, but if the borrower sells the property, the sale of the property triggers that you have to pay the loan in full. So that due on sale clause did not exist in mortgages back then. And then Fannie Mae and Freddie Mac changed the form of their mortgages, which gives a lender a right to both accelerate and foreclose. And when what it says now with the standard Fannie Mae, Freddie Mac mortgage says is that the due on sale clause kicks in if the buyer sells the property or if they sell any interest in the property. So we have to think about what is an interest in the property that could trigger a lender's right to accelerate and foreclose. And among the things that can trigger this is a contract for deed. And how do I know that a contract for deed is an interest in property? Because it's right in the mortgage itself. The Fannie Mae mortgage defines an interest in the property, which again triggers due on sale rights, acceleration foreclosure. It specifically includes a contract for deed and an installment sales contract. So if the seller has a loan in place, these two structures that I was just talking about, contract for deed and wraparound mortgage, neither of them are going to work. Both of them are going to trigger due on sale clauses with your lender, and it's going to be a risk for the buyer, a risk for the seller. Now, I'm a big boy, and I certainly know that there are people out there who are doing these deals anyway, and you're all big boys and girls. If your clients want to do a deal and take on this risk, that's their business, but you should go in with your eyes wide open and know that this is a risk. All of which brings me back to the issue of the lease option. The lease option is one structure that, particularly if a seller has a loan in place, is probably not going to violate your due on sale clause. It is arguable that an option to purchase property is an interest in property that could trigger a due on sale clause. But since it's not specifically identified in the seller's mortgage, you certainly have a fighting chance of arguing that it's not subject to the due on sale clause and therefore not subject to acceleration or foreclosure, at least not until the buyer exercises their option. All right, so let's talk about the basic structure of a lease option. The first is the lease agreement itself. And in almost all of these, what I'm calling creative structures, there is a lease agreement in place along with something else. Lease agreement, usually typical to have it be 2 to 5 years. It's typical to have a security deposit for every lease, but it all depends. If a buyer is making a substantial option payment on the option side, let's say you're selling property for $800,000 and the buyer's putting $250,000 down as an option payment, would be eventually credited towards the purchase price. Seller or landlord may be easy on the buyer tenant in putting up an additional security deposit under the lease, knowing that they're getting a big option payment on the option side. In terms of the base rent, again, this is all negotiable, but one way that sellers look at this is that they look at the lease payments by analogy to a seller financing. So for example, if the buyer is putting down 20% as an option payment, and under a seller financing situation, they would be financing 80%. And let's assume that the seller would want 6% interest per annum or something like that. So one way you might structure the lease payments is to parallel that. So the rental payments, or what we would call the base rent, is equal to 6% per annum on the 80% that is not paid by the buyer at the closing. The second aspect of these lease agreements is that they should all be triple net. If you're familiar with a triple net lease, it basically means that the buyer is responsible for all property costs. So on top of the base rent, which, like I'm saying, might be 6% of the 80% of the purchase price, it might be something else that you all negotiate. But on top of that, the assumption in most of these deals is that the buyer is paying on top of the base rent all property costs, including property taxes, including property insurance. Some of the insurance, because it's titled in the name of the seller, is going to have to be paid by the seller. The buyer cannot insure the property as a tenant. So there's some cost that the seller is going to have. So you charge it as rent. Property taxes, insurance, utilities, HVAC maintenance, pest control, lawn care, HOA, pool maintenance, and so forth. One of the negotiations that might come up is structural repairs. This is all subject to negotiation. What happens in the event of a casualty? All subject to negotiation. But the principle is that the buyer is paying all costs. So that's the lease agreement. The next contract is the option agreement. Now I have these on your slide listed separately: lease agreement, option agreement, purchase agreement, closing documents. And indeed, there are many, many closings where I create them all separately. there are some good reasons legally why it should be done separately. There are some times when people prefer them to be combined. I've had clients who have asked me, they had some political reasons with their sellers why they felt more comfortable having the option purchase terms essentially be incorporated into the lease itself. We can do that, but I'm going to talk about them conceptually differently, and cosmetically you can work this out with your attorney. So the option agreement is basically a consideration that is paid by the buyer upfront to purchase the option, the right, but not the obligation, to purchase the real estate at a later date at a specified purchase price. The term of the option, when you can exercise the option, parallels the lease period. If you have a 3-year lease period, you'd have a 3-year option term. Sometimes you put down, the buyer, I've seen the buyer put down maybe $100,000 to get a 3-year option, but they want the right to be able to extend that for another 2 years if they're still not able to finance that. So if you do that, you have to have in your lease agreement a right to renew the lease for 2 years to parallel the option period. The exercise of the option is part of the option contract, and that's usually just a notice to the seller saying I'm exercising the option and specifying a date that you'll close the purchase, usually within 15 to 45 days after the date that you notify the seller. So some issues that come up with these kind of lease options are title issues. What I typically do for both the buyer and seller, frankly, is I do a title search for the buyer up front so that the buyer has pre-approved all the title exceptions. So there might be, let's say you're buying property for $800,000 and there's a $400,000 mortgage on the property. The buyer would approve that as an encumbrance on the property for the period of time when the buyer is living there as a tenant. Then obviously it would have to be paid off at closing. But if there are judgments against the property, if there's a prior option to another guy, if there's code enforcement liens or a mechanics lien for a notice of commencement that somebody did when they did a re-roofing job, all of these, ideally you want to pay out. I do what I call an option closing, where we close on the purchase of the option, but not the purchase of the property. And at the option closing, we take the funds that we would apply towards the option payment, and we would pay off any of these judgment liens, mechanic liens, code enforcement liens, so that the buyer gets clear title subject only to a potential mortgage loan for the seller, which would be paid off at the property closing upon the sale. The second thing is the home inspection. Both of you, well, actually, to finish out this title thing, then what we do is we have, let's say 3 years later, the buyer is now capable of financing this. Well, the buyer should have the right to update their title and survey and make sure that nothing new happened. Seller is still on title for the 3-year lease term. Therefore, the seller has the ability to put judgment liens on the property. So the buyer wants to be able to have the right to update the title. And if there's any new title defects, the buyer has the right to object to that and make sure that that gets paid off at the closing without it encumbering their property when they take title. The inspection, so that's the title issue. The home inspection, again, before I have an option closing where I close on the option, I make sure that the buyer approves the current status of title. I also want the buyer to approve the current property condition of the property. So that means doing a home inspection and then the purchase contract, essentially waiving your contingency to terminate based upon things that a buyer might discover during the home inspection. So there's always a timing issue here. Do you wait until you have the home inspection before you sign the lease and the option and the purchase agreement? Do you wait to get the title first? Sometimes they sign all these contracts, but then don't have what I call this option closing until you get the home inspection finalized and satisfactory to the buyer and the title satisfactory. You don't always have a right as a buyer to have a second bite at the apple for the home inspection. Why? Because you're living in it, you've inspected it before you became a tenant, and as a tenant, you have the obligation to maintain and repair the property. So most sellers are not going to give you a second contingency on the home inspection, but will give you a second contingency on the title. So these are issues that come up in the purchase contract. I often use, in terms of documentation, I often use a standard FAR/BAR contract with an addendum. And in the addendum, I describe what I would call the option contract terms, that you're paying an option to purchase this property, and notwithstanding anything in the FAR contract that says the buyer is obligated to purchase it, I clarify it that it's just an option to purchase it within this period of time. But if a buyer exercises their option, then the terms in the FAR contract will apply. That means the purchase price. That means the obligation of the seller to provide the deed, things like that. You often in an lease option situation want the buyer to waive a financing contingency. If it's at the buyer's option to close or not close, hopefully they can use their fact that they're not obligated to close anyway to get financing if they want financing without the ability of exercising the option, saying that they're going to proceed with the closing, and then having a right to back out. Once you exercise the option, you should be closing. Most parties do not require the buyer to pay an additional down payment to exercise the option. Usually they're just doing a march towards the closing, but there's nothing wrong in asking for that if the negotiating power of the parties will permit that. And the last thing I'll mention is the HOA approvals. Many of the deals I've done have not had HOAs involved, but it's something to consider. Again, you might need an HOA approval for the leasehold up front, and then have to get HOA approval for the eventual sale if the buyer exercises the option. All right, the next topic here is closing documents. That's the basic structure here. Closing documents is that a buyer should not want to part with what could be a substantial down payment, a non-refundable $100,000, $200,000 option payment, unless the buyer makes sure that third parties are on notice that the seller cannot sell the real estate to somebody else without being on notice that I, as a buyer, have a recorded option to purchase it. You don't have to disclose the terms, you don't have to disclose the purchase price or the down payment, but it is typical to say this buyer has an option and that the option has a 3-year term extendable for this period of time. So the buyer is going to want that recorded in the public records. The seller is going to want a notice of no liens recorded in the public records. On the leasehold side, the seller can state that any mechanics liens that are done are liens that will lien the tenant's leasehold interest and not the seller's, landlord's, fee simple ownership interest. So these are two things that I typically encourage the buyer and seller to put in the public records to make sure that the world is on notice of these issues. So at the option closing, as discussed, I typically have had the parties have had a homeowners inspection, the title and survey has been approved, an option payment now gets paid, they pay off any liens, and they now start their lease. And hopefully within 1 to 2 years, they come back and come back for a closing. Now, there are some Dodd-Frank considerations. A landlord is not typically considered a lender under Dodd-Frank, but if some of the rental payments are being credited towards the purchase price, a landlord could be considered a seller and have to be complying with the Dodd-Frank provisions. Actually, one thing I forgot to mention is that if you don't qualify for Dodd-Frank at all, there is always somebody out there who's a licensed mortgage broker who will, frankly, for a fee, do the disclosure that you need to do legally that you as a seller are probably not prepared to be able to do because you've never done it before. So you can always get past these and do this legally. But even in a lease option situation, just be considering if rental payments are credited towards the purchase price, have your attorney look into Dodd-Frank considerations. All right, so when is a lease option a good deal for you guys? It's an advantage to a buyer, ideally to resolve short-term financing hurdles. Same thing as with seller financing. It's a buyer who expects to be in a better financial position in a few years from now, will appreciate the structure and appreciate the time to rebuild his or her credit. Second thing is it locks in the purchase price, so you avoid the risk of the property going outside of your reach in terms of the price within a couple of years. And eventually the buyer is to have a trial period. I can already see from the time that I'm spending on this, I may not get through the whole talk within the hour. So I'm going to skip ahead to one interesting point, and that is that in most lease option situations and lease purchase situations, the key that most of the parties are looking for, the seller is looking for a big down payment. That's their inducement to tolerate this deal in the first place. And the buyer is looking for flexibility in terms of when they have to close. That's what they're looking for. There are some situations where a buyer can't come up with a significant down payment. Maybe they can only come up with 5%. Maybe they can't come up with anything. Maybe the seller still wants to sell it to them. Maybe the buyer is a relative, or maybe they just are stubborn as seller and they want their purchase price and the marketplace isn't ready for that yet. So what you can do in this situation is have the purchase price, instead of being a pre-stipulated purchase price, that the buyer and seller agree that in 3 to 5 years, the purchase price will be X, you can have a formula purchase price that the buyer has the option to purchase it, but the purchase price is something that will be at market price. Now, a prudent buyer, if they really want the property, if long-term goal is to own the real estate, should not be satisfied with simply a vague mention to market price. But I have seen buyers and sellers negotiate what that means, and you have a procedure by which the first step is for the buyer and seller to negotiate in good faith for 30 days to determine what market price would be. If you can come to terms, that's the purchase price. And again, all these are situations done typically where a buyer cannot afford to put down the substantial payment, and therefore the seller, if they're not getting a big payment down front, is not willing to let go of the future appreciation of the property. So the first step is you negotiate in good faith between buyer and seller 3, 4 years from now, 5 years from now, what will the purchase price be? Number 2, there's an appraisal process. If buyer and seller can't come to choice, then the seller hires their own independent appraiser, the buyer hires their own independent appraiser, and you have 2 appraisals. If the appraisals are within maybe 5% of each other, then you split the difference and that's the purchase price. If there's a wide disparity between the 2 appraisals, what I typically encourage is for the parties to require each appraiser to appoint a third appraiser to pick one or the other. And the reason why you want that, rather than having the third appraisal pick something in the middle, is because if each of the first two appraisers, buyer's appraiser, seller's appraiser, knows that they're subject to being selected for accuracy by a third-party appraiser, they're more likely to be accurate in how they're going to appraise the property. So that's another option. A disadvantage to a buyer, by the way, for doing a lease option, is you don't get homestead protection on the property. If you do seller financing, a buyer can get homestead protection. Another disadvantage is a possible disadvantage is that the seller could create liens. But again, you try and minimize that by pre-approving the lease. You can put something in the public records that I don't know how enforceable it is, but basically restrains the seller from putting liens on the property. There are ways of managing that. Advantages for the seller of doing a lease option is to manage your risk. Particularly when you're thinking about seller financing versus a lease option. One thing to be aware of from the seller perspective is that it is significantly easier, cheaper, less time consuming, less burdensome to evict a tenant who fails to pay a rent than to foreclose on property that where you have to get title back. So in a lease option situation for a seller, you already own the property. So it's much cheaper and easier to get the tenant out and then just resell to somebody else. The disadvantages to seller is really just taking the risk that the buyer can't perform. If the buyer cannot finance after 3 to 5 years, then you're kind of stuck having made a bad deal. But when you said you have made a bad deal, if the seller gets a good down payment up front as an option payment, that option payment would be credited towards the purchase price if the buyer is able to exercise the option. If the buyer is not able to exercise the option, then you as a seller have gotten $100,000 down payment that you've already gotten paid, and you can sell the property to somebody else. So even though a risk is that the buyer is unable to perform, with a good down payment, it's a manageable risk. The second disadvantage for a seller is if the property appreciates. You as a seller typically lose out on the higher purchase price selling it 3 to 5 years from now. But again, if you get a significant down payment now, you're getting that covered, plus assuming the tenant is performing under the lease, you're getting all of the carrying costs covered for 3 to 5 years, or even if they have a default for 2 years, and they're paying you something in addition on top of the carrying costs. So these are risks to the seller, but of non-performance by the buyer, but they're manageable risks. The last thing that I really wanted to say to everybody about the lease option structure is for you as realtors. So you have to check your listing agreement and make sure that you are able, if you want to do one of these creative structures, make sure you can commission this. If you guide your buyer or seller into a deal where you only get paid upon a sale, meaning a transfer of title, seller financing gets you a commission. Conventional financing or an all cash deal gets you a commission. A lease option doesn't transfer title. So you would want to make sure that your listing agreement says that you get commissioned in the case of an option of the property, or maybe in the event, maybe you get a commission on the lease, or maybe both. And also be really clear that at least a portion, ideally half of the commission, if not all the commission, it's all just negotiable. Probably have to negotiate this with your broker, but make sure that your listing agreement allows you to collect a commission at the option closing, which avoids you having to wait for your commission 3 to 5 years until your buyer exercises the option. All right, I'm going to go on to the next slide, and I realize that we're running out of time for question and answer, but the good news is I can be Speedy Gonzalez on this, because this topic is the lease purchase. And really, everything in a lease purchase deal is the same as in a lease option, with one big difference, and that is instead of the buyer being obligated, having it at their discretion to close in 3 to 5 years, they are obligating themselves to close. So one thing I just wanted to say about this is that there is, you have to have a remedy as a seller. A lot of contracts will be drafted to say that the only remedy a seller has if a buyer fails to perform. Remember, a lease purchase is really a delayed closing date. This is a purchase contract. So if you're obligated, the buyer's obligated to close within 3 years and fails to do so, if the only remedy you have under your contract as a seller is to collect the earnest money deposit, you may have already received the earnest money deposit. Essentially what we do in a lease purchase, as opposed to a lease option, is the upfront payment, instead of being characterized as an option payment applied towards the purchase price, we have it be an earnest money deposit credited towards the purchase price. But the earnest money deposit typically would be, instead of paid to an escrow agent or a title agent, it would be paid to the seller, again, non-refundable for any reason other than maybe the seller defaulting and refusing to sign a deed at closing. The seller has seller remorse. I had a fun slide as I was preparing for this lecture where I found a picture of somebody who had seller's remorse. It was very funny. I'm sorry I don't have that slide for you, but just Google it in your plentiful spare time. It's a lot of fun. In any event, the remedy that you want in your contract is going to be the remedy of specific performance. That means that you as a seller are not limited to just the earnest money deposit, but you can go to court compelling the buyer to complete the sale. First of all, a standard FAR bar contract, most of these standard contracts do have an alternative remedy to seller, including specific performance. So you should be in good shape if you're using a standard FAR bar contract. You can always check with your attorney if you're representing a seller and make sure it's in there. But even if you have a right of specific performance, we have to think through what the real advantage is to you of a seller of having a right of specific performance. If your buyer is defaults, right? The 3 to 5 years go by and it's now time for the closing date and it's time for them to close. By golly, they have an obligation to close, but they don't have the money and they're still not in a position where they're able to finance it. Or maybe they just don't want the house. How can you compel them? Certainly if they don't have the money, then a lawsuit for specific performance, you can't get blood out of stone and you're not going to be successful at it. So it's going to cost you money in court. It's going to cost you legal fees. It is not necessarily a great advantage to a seller. At the same time, it creates psychological advantage. There's nothing, you know, it's nice to have the leverage, certainly as a seller, to argue to your buyer that you have an affirmative obligation. Our closing date is coming up in 60 days. Figure it out or work out a deal with me. And maybe you extend the closing date for another year and get them to put down another 50,000 or 100,000, or you get out and sell it to somebody else, but you have some bargaining power. So I've raced through lease purchase. I'm at 3:30. Jessica, do you need time for Q&A, or should I continue the remainder of the presentation? Jessica, can I hear you?
Yes.
Jessica, I see that we're at 3:30, and I'm wondering, do you want the full 15 minutes for Q&A, or should I continue my presentation? I have a little bit more to go.
All right. Does anyone have any questions? You can go ahead and chat them in the box. If you don't, we're going to go ahead and let Gary finish on with his presentation.
No, just a reminder to everyone that this was recorded and recordings will be available
All right.
You're good to go?
I'm good to go. Okay. I'm now up to the next structure. Okay, lease purchase. I'm getting rid of that one. Right of first refusal. Now, this is typically not a structure that is used by a realtor who's traditionally doing sales of property. It's traditionally not done with residential property. It is more often done by commercial realtors as an ancillary thing to a lease. But it is something to be considering as a creative, unconventional structure, so to speak, of how to get parties into a deal. The one thing I want to say about a right of first refusal is that I want to distinguish it from a right of first negotiation. If you're going to go down this particular path, first of all, the most typical situation of when you go down this, go to B on the slide that talks about uses, is where a buyer or tenant is not willing to make a significant upfront payment, and therefore the seller landlord is not incentivized to commit to a specific purchase price in the future. So the seller may say, I'll give you a right of first refusal, which means I, as a seller, can go and sell to anybody I darn well please, and then you tenant, can match the price that I offer to a third party, or you cannot match it. But then the advantage to me as a seller is I'm not stuck into a specific sale price, and it doesn't stop me from taking advantage of appreciation long term. I want to distinguish between a right of first negotiation and right of last refusal. If you spend a fair amount of time doing it and the deal justifies spending the amount of time, what the buyer or tenant should be asking for is a right of first negotiation. In other words, you want to be able to say the seller will not market it to third parties. They will not list it on MLS. They will not list it with a broker or realtor. They will not take any action to advertise it for sale until they first come to you, buyer tenant, and negotiate it and see if you can come up with terms. If you can come up with terms, then they don't have to do this. But you always want the right of last refusal anyway, which is essentially, again, the right for you as buyer tenant to match a third party offer, because sometimes even if a seller landlord does not list it, does not advertise it, does not market it, sometimes somebody comes in off the street and makes an offer. So that's where you want to protect yourself. When you're doing these deals on the buyer side, they're often negotiated into leases, and they're sometimes negotiated as a separate document. And what I'd say, it depends on the motivation of the parties. If you're a tenant and you don't know if you want to buy the property in the future or not, you're really just primarily looking for a lease, but it's one of the might as wells that you throw into it. Then you might negotiate it into the lease and not sweat the details on it. But if buying the property in the future is actually a big piece of why you want to lease a particular property, then I recommend you negotiating a separate right of first refusal that gets recorded in the public records so that future buyers are put on notice. What protects the buyer then becomes a problem for the seller. What sellers will often say is that they don't want to do a right of first refusal because it creates a disincentive for third-party buyers who actually want to buy it or prepared and financially healed to perform to make an offer in the first place, knowing they're going to be spending all the time and energy to evaluate the property and make an offer, only to have it pulled out from underneath them by the tenant on their right of first refusal. So it's a catch-22. Buyers want something recorded in the public records, sellers don't. If you don't put it in the public records, it's a problem for a seller because the buyer is more likely to remember that they have an option to purchase it and come back to you if they hear it's under sale. And a landlord may forget that they had made that offer in a lease if it's not in the public records. The last thing I'd get back to is the lease option with the unstipulated purchase price. Excuse me. I only put it in this section because in a right of first refusal situation, right of first negotiation, you're dealing with a situation where you're not specifying a specific purchase price. Well, it's a reminder to consider as an alternative to right of first refusal, the lease option with an unspecified purchase price, which either is the vague market price that you're all going to fight about 3 to 5 years from now, or the appraisal procedure. And by the way, if the appraisal procedure doesn't work and people are still fighting over it, you would usually put something in that says if there's a dispute, it goes to appraisal, or something that would be a less costly alternative to going to court. So I'm now available for questions and answers. I thank you for your time. I found an increase in my practice earlier this year, particularly with the pandemic and possible recession, of buyers and sellers utilizing some of these techniques. Hopefully you'll all find many cash buyers offering the asking price, and you'll never have to come to a guy like me, but I want you to have a plan B and a plan C and help you get other alternatives so you get your commissions as you're out there marketing. All right, I'll throw it open to questions and answers.
All right, if you guys have any questions for Gary, feel free to type them in the chat and I'll read them to him. If you were a little late just attending this session, we will have a recorded version up on our website by next week, so you can review that. All right, Gary, I'm not getting any questions. I think we were all set. Thank you so much for taking the time.
I just nailed it on the head. I answered everything first time around.
You were good.
All right, glad to hear that. It was a pleasure being with you today. Thank you again to the Realtors Association for this opportunity.
You're welcome. Thank you so much.
You're welcome.